So this is just to extend a statute that we already have that says when somebody joins a tenant union, there are certain actions that may not be taken in good faith, whether that be evictions, raising the rent, fixing certain services within a unit. And that current statute gives them 6 months. This would provide an additional 4 months for those services in the dwelling units as well as evictions, but it does not at this point because of the JFS language touch rental increases other than the 6 months that's already in statute. Any questions, comments, discussions? Senator Sampson.
Thank you very much, Mr. Chairman. I want to get into, the language of the bill in some specificity, but before I do, you mentioned out of the gate retaliatory actions that you've witnessed against some tenants. Can you describe what those things are through you?
Certainly. It could be something as simple as folks being in a community room in a building, and that community room is a room where people have meetings, they play bingo, they do these things, and they had a tenant organizational meeting that I was a part of. People came to basically tell them that they could not meet there, even though that is a place that is set for them to meet because of what they were speaking about. They didn't say that specifically, but many members of that group were then served with notices to quit. So, or given warnings from property management about some of the activities that they were taking. Not saying that this is something that happens for everybody, but it's something I've witnessed myself. Senator Sampson.
Thank you very much, Mr. Chairman. And do you have any direct, this is not a courtroom or anything, but I'm just trying to find out, to the extent that this is happening, how prevalent it is and how significant this incident that you're describing is. You said that some of the tenants were given notices to quit afterwards. Is there a direct correlation? Were they told that they were going to be evicted because they had this meeting through you, or is it possible that there was some other reason?
Thank you, Senator. It is certainly possible. There is some other reason. I would say that the circumstances there during that situation seem to point to it not being so. And I know other folks who have either come to me or even members of this legislature who have attended some of these meetings have experienced similar issues. I'm not saying it's the most prevalent, but it does happen. Senator Sampson.
Thank you, Mr. Chairman. I also, by the way, I meant to say something at the start of this discussion, which is I wanted to thank the chairs for offering us a little bit of additional time today to review this language. Our agenda today, I think, has 12 items on it. 2 of them have substitute language, which was provided to us, at effectively the start of the regular scheduled meeting. So we did need a little bit of time to review it, and I don't want to complain too much that it wasn't enough time. In my view, if these things are so important, particularly this is a subject matter we've heard about for the last couple of years, it really puzzles me that the bill could not have been drafted and distributed before the start of the meeting. And it just goes to show to me, that when I really care about something, I've got it prepared in triplicate ahead of time. I'm walking into the meeting knowing what's going on and trying to make my case to people, not slapping it together moments before the meeting in some element of haste, and also making changes that, in my view, are somewhat significant. I don't even know where the folks that are behind this bill might stand on the changes, but we'll get to that in a minute. This bill, the chairman did a good job describing it, although I think a lot is left out of that description, which is what, in my view, is a very significant departure from the idea that some tenants might have concerns about what's going on in the building that they live in and wanting to get together to talk about it and maybe approach their housing provider or landlord about that. That makes perfect sense. I think most people in the world would say, that could and should happen. But this bill has virtually nothing to do with that. And as we talk about it, you will see that this bill is not about tenants. This is not about housing requirements or quality of life or the quality of a rental unit. This is about union organizing. That's what this bill is about. It is all designed to allow strangers effectively to come into the lives of individuals and impacts the arrangements that they have with their housing. And I'm not going to say that that couldn't result in a positive result for anyone, but I think it may have the impact of causing further problems in the housing market in Connecticut. You know, the housing committee, we're supposed to be addressing policy that impacts housing in the state of Connecticut. And for me, that is, you know, dealing with making sure that there's adequate and affordable housing for the people of our state, that set of circumstances that people are faced with day to day as landlords and tenants are something that they can work and thrive in as a policy, throughout the state's, codes and laws, so that, it creates opportunity for prosperity for all the parties concerned, and that, we have a legal system that protects the parties. That you could go to court if you had an issue with your landlord or you had an issue with your tenant, and you could be treated fairly and it can be adjudicated responsibly. I mean, to me, that's what the mission of this committee is. And in my view, the bill that is before us, House Bill 5258, an act concerning tenant organizational activities, it's not about housing, it's not about tenants, it's about organizing. And the bill belongs in the Labor Committee and not in the Housing Committee. And just to illustrate this, let's talk a little bit about the bill. The first thing I would like to ask, the first section, this bill's not particularly long, it's only a few pages long, and the first section looks to be mostly dealing with definitions. I'm just curious, Mr. Chairman, does this language in this bill apply to government housing as well as privately owned housing through you?
I do not think we specify that in the bill, Senator Sampson.
Well, I appreciate that it's not specified, but does that mean yes or no? Is government housing included? Would they be subject to the same requirements under this law to allow for tenant organizers and tenant organizations to exist and to do the activities that are mentioned throughout the language of the bill through you?
There can be some state and federal, there can be some federal laws that can move this will not supersede federal law, but otherwise, yes.
Okay, that's what I thought. Sorry for the delay. It was just confirming. In some cases, it could. However, this bill would not supersede federal law. So, government housing that deals with, Section 8 vouchers and things of that nature would not be subject to this. This would not supersede federal law. Senator Sampson.
Thank you very much, Mr. Chairman. I just want to say, I appreciate the response. I don't think that's a significant enough answer, though. I mean, when you say subject to government, federal law, I think we're all subject to state law and federal law, and therefore every housing entity, whether they are owned by the state, the federal government, or private entities, are subject to federal law. So are we saying that certain entities are carved out by virtue of their ownership? When you say Section 8 housing, does that mean that a landlord that owns a multi-unit building but has some Section 8 housing does not have to abide by this policy that is before us? Through you, Mr. Chairman?
No, Senator. What I'm saying is some people may be specifically carved out just based off of the rules they might have to follow based on whatever federal government either program or ownership they have, but it is not uniform across the board one way or another. Senator Sampson.
Thank you, Mr. Chairman. I don't know if anyone understood what you said. I know I didn't. I'm trying to find out who this applies to. Does this, New Haven Housing Authority, for example, they own a building. Do they have to allow these activities through you?
Yes, Senator Sampson.
Thank you. And who would not have to abide by these or allow these activities?
I don't have any specifics for you. I think we can look into those, but as I said, I'm not sure what federal laws or guidelines govern every single type of government housing. So we'd have to look into those, but I'm assuming this would cover most housing. Senator Sampson.
Thank you again, Mr. Chairman. Yeah, so as I mentioned, the first section is really all about existing definitions that are in our housing code, defining dwelling units and landlords and so forth. Section 2 is a new section, and it defines some new terms. The first one being tenant organizer. And I understand there's a definition here, but I'd like to hear the chairman describe what a tenant organizer is through you.
Sure. I'll quickly just read the definition. It's an individual who assists in establishing and operating a tenant organization and organizing tenants to address the affairs of such dwelling unit or other dwelling units owned and managed by the owner of that dwelling unit or their agents. And it is not an employee or agent of such dwelling units' current or prospective owners, managers, or agents. Senator Sampson.
Thank you, Mr. Chairman. So based on that definition, could this tenant organizer be someone who doesn't live in the building through you?
Yes. Through you. Or yes, Senator Sampson.
Thank you very much, Mr. Chairman. Could it be someone that randomly is visiting many apartment buildings, looking for people to interact with through you?
Theoretically, yes. Senator Sampson.
Thank you very much. And I appreciate the theoretically yes, but as I go, I think you're going to find out that that's the exact point of this bill. This bill is not about those individual tenants getting together to discuss with their landlord issues that they have. This is about creating community organizers, in this case, tenant organizers, to go and effectively, stir up tenants and maybe create angst for all the parties concerned. I don't think it's going to work out like the proponents' plan, that it's ultimately going to create a panacea of rainbows and unicorns. I think what you're going to do is you're going to create hostility where none currently exists. And I think that's a dangerous thing to do. What are the qualifications of a tenant organizer through you, Mr. Chairman?
There are no specific qualifications listed in the bill. It's a bill, not a job application. Senator Sampson.
Well, thank you very much, Mr. Chairman, but bills are the formation of policy that becomes law that we operate under, and people that serve in various types of professional roles, realtors, insurance agents, police officers, doctors, lawyers, they all have qualifications that are required not only within their profession, but sometimes by the state. And I'm actually kind of a person who doesn't really believe that this state license means a whole lot compared to certification from an organization that works with people in a certain business industry or activity. But when you say there's nothing specified, the answer to the question really is that there are no qualifications required. Am I correct about that, Mr. Chairman?
That is correct, Senator Sampson.
All right, thank you very much. Are there background checks required, for example, if folks are going to start entering into random apartment buildings throughout the state through you?
I'm not sure if somebody who either operates a volunteer tenant organization or a paid one has that in their policies, but it is not laid out in this bill. Senator Sampson.
Thank you very much. I appreciate you alluding to the fact that there's going to be paid tenant organizers as well. And I'm curious to know why there would be paid tenant organizers. How could they be paid, and by whom? Through you.
When I say paid tenant organizers, I'm not saying that that is a requirement, nor am I saying that might even be the norm. What I'm saying is that some organizations will come together, such as some of the advocacy organizations that we see in this building for many issues, to organize for many different issues or what they see as rights. And sometimes that comes with some paid either lobbyist, activist, or folks who do organizing work. So when I say paid, I just mean folks who are hired by some organization, probably maybe a 501c3, to engage in these activities.
Thank you very much. Would those organizations potentially be paid out of tax dollars, maybe through the form of earmarks in our state policy through you?
I do not believe that we pay tenant organizers in our current budget as it stands, Senator Sampson.
Thank you, Mr. Chairman. But is it possible that could happen through you?
I don't think it would be for the purposes of this, but yes, they could be paid for state dollars.
Thank you very much. I appreciate your confidence, Mr. Chairman, but I have no such confidence. I, in fact, firmly believe that is the whole point of this. This is to create organizations that are going to come to the state of Connecticut and to ask us for money for what they consider to be a noble activist cause. But ultimately, what's going to happen is taxpayers are going to be further burdened with more taxes to pay for further creation of nonprofit organizations that are doing nothing more than creating hostility between landlords and tenants instead of allowing these folks to work out their differences and use our current legal means. We have a structure, and if that structure, the housing court, etc., is not satisfactory, it's not working, then we should fix it. But creating advocates on the side of tenants for the purpose of coming around to various buildings and interrupting the flow of nature's course in business to create hostility, to me, does not sound like a very smart thing to do, particularly given the noble cause of this committee and where we stand in society today, which is that we need more available and affordable housing. That does not sound like a way to get it to me. That sounds like just another thing that is going to encourage people that are in the industry of providing housing in Connecticut to divest themselves of that risk that is growing exponentially every time this committee meets. The next paragraph refers to tenant organization. Can I ask the chairman to describe what that means through you?
Senator Sampson, tenant organization means an organization that is established by tenants of a dwelling unit or of multiple dwelling units owned or managed by the same owner or the owner's agent. It's established for the purpose of addressing issues related to the tenant's living environment, including the terms and conditions of their tenancy, as well as activities related to housing and community development. It meets regularly, operates independently from the authority of such dwelling units and the owner's agents. And before we continue, I heard you say that this bill is an attempt to create these tenant organizations, and just as the proponent of the bill, personally, just want to say that this is to support those organizations. They do exist. They are not things that we are trying to create, and they are folks who have gone through the various situations in which we try to protect for here. I know that I personally am not putting this forth to make sure that we are creating these organizations or creating a further discourse where we have tenants that are supported in spite of property owners or landlords. It is just to support those who are trying to improve and ensure the quality of life in their buildings. Senator Sampson.
Thank you, Mr. Chairman. I know you're a very sincere person and you mean what you say, but I have to disagree with you. You are, in fact, creating these organizations. You can say that someone is currently a tenant organizer or there is a tenant organization, but that is not the same thing as what this bill creates. This bill defines what those items are, and it creates policy that will be enforceable under our laws that gives them authority they do not currently have. So they are being created under this policy. They are not pre-existing. When we get to Section 2, small letter B, we're going to talk about the activities that these organizations are going to be able to participate in, which they cannot currently do. In fact, that's the purpose of the bill. We wouldn't have the bill in front of us. We don't need a bill to simply state tenant organizers or tenant organizations exist. You need the bill to pass a law to create some change in how our society operates and determine activities that certain people are able or prohibited from doing. And I want to correct myself. I just realized something, during this conversation, which is that I mentioned that tenant organizers have no qualifications, and I was mistaken because they have one qualification, and that is they cannot be associated with the owner, manager, or agents of the landlord. So that is the one qualification that they have, is that they have to be in opposition to the housing provider. I just want to make a small aside here. I serve on the Housing Committee and I serve on the Labor Committee, and I'll tell you, in my experience, basically what I witness coming from the majority, and again, I have a lot of respect for my colleagues. I think that they see the world differently. I think they have good intentions in most cases, but often they view the world as a antagonistic relationship between parties, where I don't think that's the way it works in most cases. Employers and employees do not have to be antagonistic towards one another. There's not always a battle between them. Sometimes those employers and employees are working in unison to better themselves. The employees knowing that the company does well because of their hard work, they will be rewarded. Companies rewarding their employees because they know that doing so will cause them to do better work. You know, this is what happens. And the same thing happens in housing as well. You know, good landlords try and take care of their good tenants. They want their good tenants to stay, the ones that take care of the property, the ones that get along well with the other unit, renters. You know, that works. You know, and if there's antagonism created, generally speaking, it's because there are people stoking that. Let me just, address the tenant organization definition that the chairman just gave me. These tenant organizations are going to be established for the purpose of addressing issues related to the tenant's living environment, including the terms and conditions of their tenancy, as well as activities related to housing and community development. We already have that. Okay? That is the activities of the landlord and tenant in their own negotiation. And it's also the housing court. If people have a problem, there is a mechanism. It already exists. This is not going to solve those problems at all. It will address them, which I'm happy LCO chose the proper term. If they thought it was going to solve things, they would have put solve. But no, they said address. Because effectively what's going to happen is they're going to address these issues and exacerbate them. That is what I expect to see happen. Also, the substitute language, which we're discussing now, which again was provided shortly before this meeting, makes a very notable difference, and that is that it eliminates from this paragraph the ability of these tenant organizations to include rent as part of their concerns that they might address. And I'm just curious, do the other proponents of this legislation agree that that should be omitted from this policy, through you, Mr. Chairman?
Well, I think partially this was done in relation to something that we will see later. I don't think that was necessarily the intent, but also you can go to your fair rent commissions to discuss these things if you wanted to discuss a rent increase. Senator Sampson.
Thank you very much, Mr. Chairman. Yeah, no, frankly, we've had a lot of testimony in this committee. I remember being here past midnight last year, on some of these housing things. And I got to tell you, the number one issue that we hear about is rent. We've already created fair rent commissions. And people that are concerned about whether or not their building is up to snuff as far as a public health concern or something like that, the resource for that ought to be the town. You have a building inspector, you have a public health department in every town in this state to address these things. We had a councilwoman here from the city of Bridgeport, and I asked her questions about, how they manage these things. She didn't have any answers for me. I don't mean to disrespect her, but I asked her how much of the budget is allotted towards taking care of building code violations or public health, and she had no answers. If somebody who's on the town council that actually determines the budget sets aside the money for these various departments doesn't know, then I don't know how it's being addressed. But that's what needs to happen. I want that to happen. If you're a tenant and you're upset about your situation, I want you to hear me loud and clear. I want you to be able to call the town building inspector, and the building inspector come out and have the landlord make the repair that's necessary. That should happen. There's no reason why you should have to wait more than even a day for anything that has to do with running water or heat. That should be resolved immediately. And other things should be resolved promptly. That's what good landlords do. I think in most cases, a lot of these problems could be solved because people that have the means, they'll simply move to another place that is not giving them a hard time and making sure that the unit is nice. It just so happens that we have this small segment of the housing population in the state that is living in less than desirable housing, probably because of their own ability and means to be able to obtain it. And this comes up all the time in this committee. So it's the people that have the least amount of money, or they have bad job history, or their credit isn't so great. Those are the people that are struggling with these things more than anybody else. And I certainly recognize that. And they shouldn't have to deal with having problematic landlords or having, their building in great disrepair. They shouldn't have to. They should be able to rely on the city government to resolve those issues. Tenant organizers, they're going to only add a desire for more money into the mix. That's what's going to happen. Nobody's going to come out and to your building and advocate on your behalf for free. That's just not going to happen. They're going to do it either because they're being compensated in some way, probably because they will come to this state government, who will gladly hand them over money that will very assuredly not be used in the best possible way to address the concern. And that's what I have a frustration about. So moving on, I'm on line 72 if anyone's reading along with me. Oh, before I go there, I noticed at the end of the tenant organization meeting, when we're defining what it is, under section C, it says meets regularly. I mean, that's one of the requirements of the definition. It's that this is established by tenants, owned or managed by the same owner or owner's agent. That's all it is. It's just a group of tenants suddenly become a tenant organization once this bill passes, and that they meet regularly. What does that mean, Mr. Chairman? What does meets regularly? Is there a definition somewhere through you?
I don't think there is a specific definition of meets regularly. I think what would qualify is you have a set schedule that you meet quarterly, you meet every 4 months. That is a regular meeting versus some sporadic kind of organizing. Senator Sampson.
So if I was to say these tenant organizations meet whenever there's a problem that they feel that they need to discuss, would that qualify as meeting regularly through you?
Senator Sampson, I don't think that you can apply whether or not problems are regular or irregular without too much of an opinion. I don't think there's a factual definition of regular or irregular problems. So if it was based on problems, I don't think it would be a meeting regularly. Senator.
All right. Well, thank you very much, Mr. Chairman. Well, that creates a follow-up. When you say that just meeting sporadically, like when problems show up, does not qualify as meets regularly, does that mean that these tenant organizations would not have the rights that are listed here based on that through you?
No. They would meet regularly. They would meet quarterly. They would check in sometimes even when there wasn't a problem. But they wouldn't just do it arbitrarily based on whether there were problems or whether they just decided that this is when they were meeting. Senator Sampson.
Thank you, Mr. Chairman. I'll come back to it because I think we should talk about the activities that are involved now. Because I think once we talk about the activities that are involved, which again, I'm going to go back to my opening statement just as a reminder, no group of tenants got together and came up with this. No tenants, you said, we're having difficulty with our landlord. We should find a way to organize, and we should petition that landlord to fix our building or what have you. That's not what happened here. This bill is about union organizing, and it's patently obvious to anyone who has spent time in this building or in politics what's going on here. And it's going to be more obvious as we talk through these activities, because ask yourself as we go through them whether these activities have much to do with fixing anyone's building or addressing affordable housing as a larger goal. So under small b, under section 2, now it says an owner of any dwelling unit except those exempted from the application of Title 47, which is what I was trying to get at earlier. I still don't know who those entities are. I'm curious to know who is exempted. But those owners shall permit tenants, authorized agents, and tenant organizers to conduct the following activities. So I just want to clarify that this absolutely means strangers. Random people that may or may not have any direct acquaintance with the tenants themselves. This could be someone who comes in off the street on any random day. Is that accurate? Through you, Mr. Chairman.
Senator Sampson, I would say that is inaccurate. It says tenants, tenants authorized agents, and tenant organizers. So that means that the tenants or tenants authorized agents, which are folks who know the tenant, who the tenant has authorized, as well as tenant organizers together, which they would not be strangers to the tenants since they were appointed by the tenants. Senator Sampson.
Thank you very much, Mr. Chairman, but the language of the bill says otherwise. I mean, maybe parsing some terms, but the definition of tenant organizer, which I've already discussed with you, says an individual who assists tenants in establishing, operating a tenant organization, and so on. But it never says anything in there. There were no qualifications. You agreed with me. No qualifications, not even that they know the tenants or they're a member of the building. The only thing is they can't be related to the owners. So those people are now going to have the following authorities. One is they can come and distribute leaflets, okay, in common areas, including lobby areas. Placing leaflets at or under tenants' doors. I don't know how many tenants that are listening to me really want to have strangers coming into their building, and that will be required by law to be allowed into your building, even if it's a secure building now. They're going to be required to be allowed to go into your building and slip stuff under your doors and leave out leaflets. And it gets better. They will have the ability to initiate contact with tenants. Even if you don't want to be bothered, they can start knocking door to door, conducting door-to-door surveys, posting information on bulletin boards, assisting tenants to participate in tenant organization activities. And this one I thought was really interesting from a perspective of, is this really about tenants and their well-being, or is it about union organizing or politics? What's it about? Number 7, holding meetings, including political caucuses or forums for speeches of political officials or candidates for public office, without the presence of the dwelling unit owners or such agent. That doesn't sound to me like some tenants getting together because they're upset about what's going on in the building and trying to find a solution. It sounds like an opportunity to create political organization and use this as a mechanism for politicians and political advocates who work with them to come into places they're not currently welcome. Because many buildings are restrictive because they want to protect the rights and privacy of the unit owners and or the tenants. Those are good things. This eliminates all those protections. Every one of those protections vanishes under this bill. It also says that these meetings, political caucuses, and forums with political officials or candidates, etc., shall be conducted at reasonable times in an orderly manner, held in any community room or recreation room, which is really owned by the owner of the building, if these rooms are open for the use of tenants or in common areas. It also says the owner of the dwelling unit or agent shall not require tenants authorized agents, or again, tenant organizers who could be people off the street, to obtain prior permission before engaging in all of the activities that I just listed, including these political meetings. So, Mr. Chairman, what is this bill really about? Can you tell me how allowing these political caucuses, forums, and speeches of public officials or candidates without the presence of the owner in the building are going to help tenants resolve whether or not they're having repair done to their unit? Through you.
Thank you, Senator. This particular section is not about that specifically, but it also is not about amassing political power. I think what it's about is tenants being able to have these meetings, organize these meetings, and speak to folks who they would like to speak to in their place of living, their complex, without having maybe management who may or may not have a particular leaning one way or the other to tell people not to organize within the building or not to have those conversations within the building. It's just a conversation, and the organizers, the tenant organizers, or the tenants of the building are the ones that are asking for it to be had. Senator Sampson.
Thank you very much, Mr. Chairman. Again, I hate to keep disagreeing with you, but it is not the tenants. It is not the tenants. You could say it over and over again, but the bill doesn't say the tenants. It says the tenant organization, or it says the tenant organizer, which we established could be someone else entirely who is not a resident of this building, who has nothing to do with it at all. They can show up and have these meetings. That's what it says. There's more to talk about. I mean, Section 3, there are some changes, but I know my colleagues also have some questions about this proposal. If we wanted to establish some clarity in the ability of tenants to have redress for their concerns, I think we could do that. But I think we ought to be focusing on the tenants and their concerns. This bill doesn't do that, Mr. Chairman. This bill is about union organization. This is about political entities. This is about nonprofits getting taxpayer money. It's just it's a mechanism. This is how this works. I've been in this building long enough to realize. I watched a union come in from another state and take over daycare providers and people that receive benefits from the Medicaid waiver program without their asking for it, to basically force them into a union so that they could collect dues. This is just a way for an entity to be created so that there is another excuse to do political advocacy out in the world, to get access where access doesn't currently exist, and also to have it funded by taxpayers under the guise that this is helping tenants, when in fact all it would ever do, if the subject in the political caucus forum / meeting ever got around to the tenants, if that ever actually did happen, all that's going to do is create animosity between all of the parties. Nothing will be resolved. We have tools for these things already. We have tenants and landlords entering into private contracts as adults, as free citizens. That's how we operate in America. Free citizens get to make their own choices and engage in contracts and determine the terms of those agreements. If one party fails to live up to the terms of that agreement, they have recourse. In this state, landlords, they would have to pay a lawyer and go to civil litigation to do it. But tenants in this state, they can get help for free. The state pays lawyers to help people with all of these problems for free. I don't know what else you need to do beyond all of that. The towns are failing. Some of our large cities are not addressing these problems. The people that are supposed to handle public health, building code violations, they're just not doing it. That's why these buildings are in less than perfect condition. That's why those bad landlords that we keep hearing about are able to get away with it. Fix what we have. What you have is a perfectly good framework. It's just not being exercised properly. But that is no excuse to go down this road. This road is dangerous and fraught with more costs and less affordability for the average Connecticut resident. And absolutely not one single additional affordable home will appear as a result of this legislation. Less. That's what we will get. Less. That's all I have, Mr. Chairman.
Thank you, Senator. And before we get to Representative Zullo and Senator, if you would like to respond, we can do that after Representative Zullo, but I just want to speak to a few things that were said. One, I understand the tenant organizers can go into these buildings, but tenant organizers are part of tenant organizations. Tenant organizations are established by tenants of a dwelling unit or multiple dwelling units owned or managed by the same owner or the owner's agent. You also spoke about the fact that this is being painted adversarially, and I understand that there is some adversity in this. I'm not going to say there isn't, but when it says that somebody is not an employee or agent of the dwelling unit's current owners, or it says somebody operates independently, I operate independently of the New York Mets. I'm a huge fan of the New York Mets. If the New York Mets were going to move from New York, I would do everything that I could if I had the power to ensure that they stayed in New York. I am a fan of the New York Mets. I'm not an agent of the New York Mets. You can be a fan of your property owners. You can be somebody who supports your property owners and still be independent of them. So I want to make sure that that is abundantly clear. And the political representation that was given to this bill, I will just say, as the main proponent of the bill, The intention is not to give money to these organizations. It is just to give support. And if the money is something that will come, that is a conversation that would be had in appropriations. I sit on that committee as well. It is a conversation I would be having on our either our conservation and development subcommittee or maybe judicial or wherever that would sit. But that is not a conversation that we are having today. The conversation we are having is just about the language before us. And I just wanted to clarify those things. Representative Zullo.
Thank you, Mr. Chair. And I don't want to jump ahead of the good senator. If they're in person and they'd like to go first, I'm happy to defer for the moment. It's up to you.
Fair enough, Senator Sampson.
Thank you very much, Mr. Chairman. And with respect to Representative Zullo, I don't want to beat a dead horse. I've said what I have to say, but I do want to go back to the language of the bill because that's all that matters. You know, we can have our opinions up here, but the bill is what I'm leaning on when I make my claims. Tenant organizers under line 75. Okay, it says that owners shall permit tenants, tenant authorized agents, and tenant organizers. Okay, so a tenant organizer could be anyone. We already established that in the definition under 1. They have all of these abilities. So I would suggest that if I wanted to go to a apartment building right now that is a restricted building and it has a you got to be buzzed in the front door and there's a security guard on duty and they do not allow political solicitation, etc., or whatever, I think that I could go there very easily and say, under this statute, you've got to let me use your community room and I want to talk to the tenants. And there's nothing in this bill that says I have to talk to them about housing. I can talk to them about anything. We could talk about ICE. Through you, Mr. Chairman.
Thank you, Senator. And the only thing I will say to that is if we would like to provide language that further specifies that these tenant organizers would have to be accompanied by tenants of such building, I am more than happy to do that. We'll take this one by roll.
A motion has been made and seconded to JFS to the floor. Agenda item number 1, House Bill 5258, an act concerning tenant organizational activities, LCO 2752. Representative Felipe.
Yes.
Senator Marks.
Yes.
Representative Scott.
No.
Senator Sampson.
Sampson is no.
It should be as amended. So
Oh.
as amended.
Let me redo it. A motion has been made and seconded to raise agenda item number 1, House Bill 5258, an act concerning tenant organizational activities, LCO 2752, as amended by amendment by A. Representative Felipe.
Thank you.
We have to vote again.
We have to vote again?
You have to tweak the language because we didn't talk about it being amended.
I had to do the amendment.
Yeah.
Okay.
So we have to vote again.
Representative Felipe.
Yes.
Senator Marks.
Yes.
Senator Sampson.
For real this time, no.
Representative Scott.
Representative Scott's a no.
Representative Roberts.
Yes.
Senator Gaston. Senator Anwar.
Senator Anwar votes yes.
Mr. Chair, I'm sorry to interrupt. Just with a point of order, I apologize. The announcement from the clerk in the motion was a motion to raise. This bill has already been raised by the committee. I just want to make sure you don't have an issue with the way the wording of the motion is. I believe the correct wording would be, I'd like to make a motion to JFS to the floor as amended. Is that not correct?
That is correct. Christian, one more time.
Thank you. A motion has been made and seconded to JFS to the floor. Agenda item number 1, House Bill 5258, an act concerning tenant organizational activities, LCO 2752, as amended by Amendment A. Representative Felipe.
Yes, yes, yes.
Senator Marks.
Yes.
Representative Scott.
Representative Scott's no. This is only one no, though.
Senator Sampson.
I heard Felipe vote 3 times. I don't know. Sampson is no.
Representative Roberts.
Yes.
Senator Gaston. Senator Anwar.
Senator Anwar votes yes.
Representative Brown.
Yes.
Representative Butler.
Representative Butler votes yes.
Representative Corpus.
Corpus votes no.
Representative Gonzalez. Representative Hall. Senator Hockedale. Representative Jensen.
Jensen votes no.
Senator McCrory. Representative Sweet.
Yes.
Representative Turco.
Yes.
Representative Weir.
No.
Representative Zullo.
Rep. Zullo votes no.
Thank you.